Welcome to the January 2016 Bond Dickinson Employment Law podcast. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the employment team here. In this podcast, I'll tell you about some of the major cases that have been reported since my last podcast, dealing with holiday entitlement, reasonable adjustments, unfair dismissal and whistleblowing. Then I'll go through the main employment law changes we expect to see in 2016 before looking at some news stories. Lastly, I'll give you some action points to take away with you. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and you can claim for the amount of time you spend listening to it. My first case is Greenfield and the Care Bureau Limited, where the ECJ looked at a worker's right to holiday when their working hours change. Mrs. Greenfield was entitled to 5.6 weeks of annual leave each year. She initially worked 1 day per week, but then increased her hours to 12 days on, 2 days off each fortnight. When she left her employment, she brought a claim for pay in lieu of untaken leave, and argued that her new working hours should be used to calculate the leave entitlement that had already accrued, even if it had been taken. The ECJ held that when a part-time worker increased her hours, her employer was not obliged to recalculate any statutory annual leave that had already accrued. The annual leave entitlement only needed to be recalculated to reflect the new working pattern. Leave taken in excess of the entitlement that applied under the original working pattern could be deducted from the leave under the new working pattern. This is a sensible decision, and it would have been surprising had the ECJ come to any other conclusion, particularly since it had already decided in a previous case that a reduction from full-time to part-time working should not lead to a decrease in the amount of leave that a worker had already accumulated. Does the duty to make reasonable adjustments apply to an attendance management policy? This was the question before the Court of Appeal in Griffiths and Secretary of State for Work and Pensions. Mrs. Griffith suffered from post-viral fatigue and fibromyalgia. Following a 66-day absence from work, she was given a formal written improvement warning in accordance with the DWP's attendance management policy. Mrs. Griffiths raised a grievance and argued that, due to her disabled status, the DWP should make 2 adjustments to the policy. The first was that it should not treat her absence as counting against her under the policy, since it resulted from her disability, which meant that the DWP should withdraw the warning. The second adjustment she suggested was that the policy should be modified to allow her to have longer periods of illness absence before she faced the risk of sanctions. Mrs. Griffiths brought a tribunal claim alleging a failure by the DWP to make reasonable adjustments. Her claim was unsuccessful in the Employment Tribunal and the EAT. The Court of Appeal held that the duty to make reasonable adjustments was engaged and arises once there is evidence that the arrangements place the disabled person at a substantial disadvantage because of their disability. However, in this case, the proposed adjustments were not steps that the DWP could reasonably be expected to take, so the appeal was unsuccessful. This decision clarifies that the duty to make reasonable adjustments will normally be engaged where a disabled employee may be impacted by an employer's absence management policy. An employer will need to evaluate the employee's disability and the levels of absence before considering what adjustments, if any, it could make. It remains sensible for employers to distinguish disability-related absences from other absences. My next case is MBNA Limited and Jones, where the EAT had to consider whether inconsistent treatment of 2 employees made a dismissal unfair. 2 colleagues were involved in an altercation at a work event. Mr. Jones punched a colleague, Mr. Battersby, in the face. Mr. Battersby then sent threatening text messages to Mr. Jones but did not carry out any of his threats. Mr. Jones was dismissed for gross misconduct, and Mr. Battersby was issued with a final written warning. Mr. Jones argued that the leniency with which Mr. Battersby had been treated made his dismissal unfair. The EAT held that Mr. Jones's dismissal was fair. It confirmed that the correct test remains whether it was reasonable for the employer to dismiss the particular employee in the circumstances. Inconsistency of treatment will only be relevant in limited circumstances, such as where 2 cases are truly parallel, which was not the situation here, as the 2 cases were not identical, Mr. Jones had assaulted Mr. Battersby, who had threatened violence but had not used it. This is a helpful decision for employers and confirms that, while employers must act consistently when considering disciplinary matters, two cases will rarely be exactly the same, and it may be reasonable to impose different sanctions in different but similar cases. In an unfair dismissal case, where the reason is long-term ill health absence, must an employment tribunal consider whether the employer could have been expected to wait longer before dismissing the employee? This was the question the EAT had to decide in Monmouthshire County Council and Harris. Mrs. Harris suffered from depression, sinusitis, asthma, and an underactive thyroid. After a disagreement with her new line manager, she went off sick and was eventually dismissed due to ill health. The Employment Tribunal found that the Council had failed to make reasonable adjustments and the act of dismissal was discriminatory. The Council appealed. The EAT allowed the appeal due to errors in the Tribunal's approach. It held that the Tribunal had failed to consider whether the Council should have been expected to wait for longer before dismissing. As the Tribunal had not addressed this fundamental question, its decision could not safely stand. Although the Tribunal accepted that capability was the reason for the dismissal, the question was whether the decision to dismiss was fair in all the circumstances of the case. The Tribunal's reasoning needed to demonstrate that it had considered whether the Council could have been expected to wait longer, as well as the question of the adequacy of any consultation with the employee and the obtaining of proper medical advice. The EAT gave no guidance as to how long an employer should wait before dismissing, as this will depend on the facts of the case. However, employers should always follow their own policies, obtain medical advice, consult with the employee, and only consider dismissal as a last resort. My last case is Underwood and Encantan plc, where the EAT looked at whether a dispute between an employer and 4 employees about the contractual terms of their employment was a matter capable of being in the public interest so that a whistleblowing claim could be brought. Mr. Underwood was an HGV driver with Encantan plc. Together with 3 of his colleagues, he submitted a written complaint regarding their terms and conditions of employment, including the way in which overtime was allocated among drivers. He was dismissed several months later. He issued a tribunal claim alleging that he had made a protected disclosure and that his dismissal was automatically unfair. His representative made written submissions which included a vague reference to the fact that some of the drivers who were given less overtime had issues regarding the safety of the vehicles they drove. The employment judge struck out the claim and held that a dispute about terms and conditions was not in the public interest. Mr. Underwood appealed. The EAT held that the Employment Tribunal had taken too narrow a view of the term public, failing to recognise that it could refer to a subset of the general public. The claim could therefore proceed. There was a suggestion that the drivers had raised concerns of vehicle safety and roadworthiness, which raised wider issues of road safety and could be a matter of public interest. The EAT had already come to a similar decision in the case of Chesterton Global Limited and Nomo Hamed, where it held that a group of 100 senior managers was sufficient to satisfy the public interest test. Chesterton is being appealed to the Court of Appeal and is due to be heard in October. In the meantime, the Underwood case takes this decision one step further, and employers need to be aware that an alleged breach of contract that affects a group of employees could be sufficient to satisfy the public interest test and allow a whistleblowing case to proceed. Next, I'm going to look at the principal changes to employment law that we expect to see in 2016. Since the 11th of January, workers on 0 hours contracts have had the right not to be unfairly dismissed or subjected to a detriment for a failure to comply with an exclusivity clause. There is no qualifying period of service, and the remedy is a claim in the Employment Tribunal. The new national living wage is due to come into effect on the 1st of April. This will mean that workers aged 25 and over will receive an additional premium on top of the national minimum wage, and from the 1st of April this will result in a national living wage for those workers of £7.20 an hour. It has been estimated that around 50% of employers will need to increase pay for some employees as a result of this change. On the same date, penalties for a failure to pay the national minimum wage or living wage will double, and company directors can be disqualified for failing to pay the correct amount. On the 1st of April, penalties will be introduced for employers who fail to pay employment tribunal awards or sums due under Cot 3 settlements. The penalty will be payable to the government and will be 50% of the award, subject to a minimum of £100 and a maximum of £5,000. Another long-trailed employment law development, gender pay gap reporting, is due to be introduced this year. It was expected to come into force by the 26th of March, but is likely to be delayed. All employers with 250 or more employees will need to publish information on the gender pay gap in their workforce. The government consulted on the detail of this proposal, such as where companies will need to publish information and how frequently it will need to be published, in the summer of 2015. We are still awaiting the outcome of that consultation, which is expected shortly. However, the government announced in November last year that the reporting requirements will cover public sector as well as private sector employers and will include bonuses as well as basic pay. From the 31st of March onwards, every organisation with a global annual turnover of £36 million or more that carries on a business in the UK will have to publish a statement on its website setting out the steps it has taken to ensure that there is no slavery or human trafficking in its business and supply chains. Alternatively, it can state that it has taken no such steps, although to do so would risk negative publicity. Although this is not a pure employment law matter, in-house employment lawyers and HR professionals may find themselves becoming involved in preparing these statements, drafting policies, and organising training for staff. The government has recently launched a consultation on draft regulations allowing for the recovery of exit payments made to public sector employees who subsequently return to the public sector. The consultation on the draft regulations closed on the 25th of January. The proposed regulations will apply to public sector employees who earn in excess of £80,000. If they return to any qualifying part of the public sector within 12 months of the termination of their employment, they will have to repay a proportion of any exit payment they received. The regulations will apply to almost all public sector organisations, with the main exceptions being nationalised banks, broadcasters and financial regulators. This new provision is expected to come into force in April. The Prudential Regulation Authority and Financial Conduct Authority have issued policy statements on whistleblowing in banks, PRA-designated investment firms and insurers. These set out rules designed to increase whistleblowing in the sector and create a culture where employees are not afraid to come forward and express their concerns. The main rules come into effect for affected businesses on the 7th of September, but by the 7th of March, all affected firms need to have appointed a senior manager as a whistleblower's champion. We do not have a definite date yet, but we could also finally see the introduction of regulations to outlaw caste discrimination this year. Proposals to cap public sector exit payments at £95,000 may come into force in 2016, and it is possible that the trade union bill will complete its passage through Parliament, which will mean new rules on strike ballots and limits on picketing. And now some employment law news items. George Osborne gave details of the government's spending review and the autumn statement at the end of November. Several announcements were made that are relevant to employment law. The apprenticeship levy will be introduced in April 2017 and will be set at 0.5% of an employer's wage bill. A £15,000 allowance will be made available to offset the cost, so that employers with a wage bill of less than £3 million will not have to pay anything. The levy will be paid through PAYE, and employers in England will be able to access funding through the digital apprenticeship system. The levy will apply across the whole of the UK, but apprenticeships are a devolved matter in Scotland, Wales and Northern Ireland, so the government is liaising with the devolved administrations over their arrangements for giving employers access to the fund. It is expected that employees will effectively pay for the levy in the form of reduced wage rises. Free childcare of 30 hours per week for parents of 3 and 4-year-olds will be introduced in September 2017, but will only apply to parents working 16 hours or more per week and earning £100,000 per year or less. it will be worth up to £5,000 per child. There will be a real terms increase in spending on access to work. Finally, the Fit for Work service will be expanded, although no details have been given yet. The Chancellor has announced that he will extend shared parental leave and pay to working grandparents to recognise the crucial role grandparents play in providing childcare. Evidence suggests that nearly 2 million grandparents have given up work, reduced their hours, or taken time off to help reduce their children's childcare costs. The government intends to consult on draft legislation in the first half of this year and to bring the legislation into force by 2018. The government has published its proposed benefit and pension rates for 2016 to 17, under which the current weekly rates of statutory sick pay and maternity pay, as well as other parental payments, will not rise in April 2016. We are waiting to find out whether tribunal limits will increase or not. Lastly, ACAS has published a report setting out the trends it expects will have an impact on workplace relations over the coming year. The report identifies workplace bullying, pay, the new trade union bill, and productivity as key workplace trends to look out for in 2016. There are several action points that you should consider as a result of the matters I've covered in this podcast. Check that, where an employee's hours of work change during the holiday year, you recalculate their entitlement from the date of the change onwards. In relation to disabled employees, consider whether any reasonable adjustments need to be made before you apply an attendance management policy, and ensure that you distinguish between disability-related absences and other absences. Remind managers that where 2 or more employees are accused of the same offence, they can only impose different sanctions where the cases are not truly parallel. Be careful when an employee raises a grievance about their terms and conditions. If it affects other employees as well, it could constitute a protected disclosure, enabling the employee to bring a whistleblowing claim. Lastly, assess whether the national living wage will impact on your organisation, and if so, consider how you will fund it. I hope you found this podcast useful. Please get in touch with your usual Dickinson contact if you have any queries. Thank you for listening.